first, let's go across to senior advocate Sanjay Hegde, who was fighting for the rights of the women who felt they should be allowed to wear a hijab. Now, Sanjay, as you know, the court has declared that this is not an essential practice of Islam. Do you believe, firstly, that the last word on this has been spoken, or is this a matter that you're planning to now take all the way up to the Supreme Court?
Of course, not only my clients, but many others are planning to take the matter all the way to the Supreme Court. Even if they did not, the people who are not parties to the High Court proceedings could take it up with permission to file in the Supreme Court. I believe it's going to the Supreme Court. Possibly, petitions have already been filed.
Okay, as soon as that, you're saying almost immediately a review will be filed, an appeal will be filed in the Supreme Court.
Especially if petitions will be filed. They may not come up for hearing immediately because we have a holy break coming up shortly. But next week sometime, maybe we'll see the matter hitting the Supreme Court.
Sanjay, with the benefit of hindsight, do you believe that to frame this debate within what is an essential practice of Islam or not may have been an error? And I ask you this because the Sabrimala verdict also followed a certain trajectory in the Supreme Court, where the Supreme Court ruled, that this was not an essential sort of practice of Hinduism and wanted menstruating women to be allowed, and now is having to review its own verdict. Do you believe that courts can be the arbiter of what is or isn't an essential practice of a religion?
Well, courts themselves have been uncomfortable. Justice Chandrachud has said that deciding what is essential religious practice and what is essential to religion, these are two different things, but courts have been willy-nilly been drawn into it. And this is something which has happened way back in the early years of the Supreme Court, right from 1954. And that decision of the Supreme Court also references debates which happened in the Constituent Assembly. Essentially, what seems to have happened is that religious issues then end up going all the way to the courts, and the courts have to end up giving a judgment. So even however much they dislike interpreting religion, they're forced to do it.
But do you believe that this was about the fundamental right involving the freedom of religion, or do you believe that it was about the right to education?
No, there are several rights involved. The essential religious practice doctrine is only one of the arguments. It pertains to the right of practicing religion. There was also an argument made that you have a right to conscience. And if people in good conscience believe that it is a religious obligation to do some X or Y, then there must be maximum accommodation for that position. You remember the movie Chariots of Fire? The runner who could not run because it was a Saturday. It came in with his religious beliefs as far as the Sabbath was concerned. So these issues often come up in daily life. Sometimes you have the requirements of your work, the requirements of your profession, and you also have your religious beliefs. What most societies and constitutions do is to find a workabout where both can be given effect to. It is not a binary. This particular issue seems to have been framed as a binary, and all kinds of arguments were addressed. The Karnataka High Court, to my mind, made a mistake when it split the fundamental right to religion and the fundamental right to conscience, on the assumption that fundamental right to conscience meant it was protecting the rights of those who did not believe in any organized religion. I do think that people with a religion also have a conscience, and people with a conscience may also follow some parts of religion.
But Sanjay, the women you were representing have now held a press conference, and they've said they will continue to demand the right to wear a hijab until such time they will not be going to study. Now, surely this is carrying it too far.
Well, that is exactly what it is about. Choice. They have a choice to study. They have a choice to be believers. And if the two choices conflict, what do they choose? That's entirely up to them, isn't it? Justice Krishna Iyer in a judgment called Jagdish Saran had a phrase called martyrs of the Constitution. If they choose if they cannot access government education in a manner consistent with their religious beliefs, that is their choice. Maybe they'll go to a private college which does not does not have uniform requirements. They, a wise administration will know how to accommodate.
Yeah. How do you characterize the verdict today? What is the word you'd use for it?
I would think that the inarticulate major premise of the judgment seems to be that rights are those which are conferred by courts. Rights exist in the Constitution. Courts have to implement them. If courts give way to executive fiat and to rules where even the statute does not make any specific provision, then I do think that such judgments have to be reviewed.
Okay, final question to you. Are you disappointed, or is this along expected lines, what happened with the verdict? Until such time as the Supreme Court takes a decision on this, borrowing from the Sabrimala example, what would you advise these young women who are staying out of the educational institutions to do?
Well, I don't think I'm in any position to advise them, particularly on religious matters. How can you advise them?
Because there are many Muslims. There are many
You can
Muslims.
only tell them
There are many
these are
Muslims.
your choices.
But there are many Muslims who do not think that the hijab is essential to Islam.
Absolutely. There are many Muslims who drink, and that doesn't make them less Muslim. But it is ultimately, I think the answer is in that Abida Parveen song, "Main jaanu mera khuda jaane." So when somebody has a religious belief, do you say, on the other hand, in administration, okay, you keep your religious belief and get out of my life? Well, you can do it in personal life, but in a state which is supposed to provide for all and which provides education without any reference to caste, gender, or religion, can you not make provisions to accommodate?